everybody. My name is Ori Aronson, and thank you all for coming and to welcome everybody to the final event of this academic year of the Center for Jewish Democratic Law at our faculty. And even though this event is part of a long series that's been going on for several years now, what we call in Hebrew Mishpatim Mifgashim, or in English Comparative Commons, in which we normally bring together a scholar of religious, Jewish, perhaps law, and a scholar of public law or secular law in a similar field. So this is a continuation of that series, but this is also an exceptionally unique event in which we are honored and privileged to host two very special figures in conversation. We have with us Justice Neal Hendel of the Israel Supreme Court and Professor Jeremy Waldron from NYU in the US. Professor Waldron was also a member of the conference we had here. Actually, Justice Hendel as well. We're both participants in the big conference we had here over the past couple of days. I want to thank you both for coming back for one more special, slightly less formal event in a form of a conversation. It's sometimes the laziness of the introducer, but I think that this time it's actually genuine to say that these two personalities need no introduction. I just mentioned perhaps that both of you, in some sense, share the life experience of living in a country other than the one you were born and raised at, and I wonder whether that can also sort of, contribute something to your conversations on the dignity of government. As agreed, I'm passing over the microphones to you, and let's all have fun.
Good, thank you. Thank you. As agreed between us, I will start. First, I want to say that it's a big honor to be here, and I welcome all of you. I will just mention Shachar Lifshitz, the dean, and how much respect and admiration I have for your moving forth the project of the center. It's very, very important. It's hard to think of things that are more important. And also my colleague, Justice Meltzer. I'll just say I'm very glad that he's on the bench when I'm on the bench, because one of the clear contributions that he has is that he's very interested in comparative law. And if you have someone else who's interested in comparative law, it pushes you a lot. So I'm grateful for that assistance. I wish to talk about two cases where I make reference to Professor Waldron. I'm very honored to speak with Professor Waldron. There's an expression in the Talmud which I think applies, that I include myself, that they were all like students sitting at the master's feet. And it's a very big pleasure to be here, and I think it's an interesting example, and I'll get to it in a second, that I've been thinking about the issue of government, of law and government, what's more important, legal theory, jurisprudence, political theory, and I think, and I say this in general, that there should be more interaction between law and other fields. Law and psychology, law and sociology, law and religion, law and culture, and law and political theory. It's something that's very, very important. If it's not done, it's missing, and it's one of the discussions with Professor Lifshitz about this, that it's also something that can be missing. I was blessed in the sense that I didn't go from high school to law school, but like other Americans, I studied a lot of different subjects in university, and here, of course, you start university with law school, and it's important to expand the horizons, and I think this case, or the discussion, will highlight that. I'm going to talk about two decisions. Perhaps later we'll get into a third, where I mentioned, or I refer to Professor Waldron. I'll explain exactly why I referred to him. The first case that I will refer to is a case having to do with B'nai Brak, and that's the Ruchmankin case. which was given in 2015. I'm not going to get into details of facts too much because it's not that important. I'll just say B'nai Brak, and I say this to also so you're totally in the picture. It's a community, a city which has a lot of ultra-Orthodox religious Jews in the government, in the municipal government, and that's also part of the reference. One of the reasons why I brought in Jewish law as well in the decision. Basically what was involved was a decision of the Tel Aviv Administrative Court, which decided that someone should continue to be the minority representative in the Municipal Property Tax Discount Committee, which is a very, very important committee, Arnona, as it's known, and it's something which is very, very important. And there were all sorts of questions because in the beginning this person who was chosen was part of the majority. That is to say, he was the party that got the most votes. He was part of it, and then he just left it, and he suddenly found himself in this position. He became a one-person party, and he was chosen for this. Also, he was chosen for this because the majority wanted him, and there were issues whether it shouldn't go to a different party that was in the minority to begin with. Now, in the course of the discussion, I felt this was an opportunity to talk about government, to talk about what the Supreme Court can do with issues of government. We'll get to this a little bit later, but we have, and I'm saying this as well for you, we have the Human Dignity Law and Freedom, which puts great emphasis on human dignity, and a lot of rights have developed through the use of this law, the criminal law, property law, and so forth. But I think it's time that the Israeli government is viewed in the Supreme Court through the lens of a philosophy, of an approach, that it's not just technical questions, that it must be broader. It must be understood in a much broader way. And this is something very, very important. There's a wonderful book, The Dignity of Legislation. We both have our Bibles with us. The book, which I'll quote parts that I mentioned in my decision, the title fascinated me, although I didn't stop at the title. What's important is the notion of dignity. Now, we tend to think of dignity as human dignity. Humans have dignity. That's one of the aspects that makes humans different from other parts of creation. But I felt that it's important to say, what is government? What do we want from government? What does it mean, the dignity of legislation? What do we want from the legislation? And I think we want something, and I think we should want something, and we should try and upgrade what the legislation is. I mentioned that there's a three-stage process of minorities. The first process, or the first stage in history in terms of minorities, was the recognition of majority rule. The majority rule goes back to the Bible. There it says, that you have to go according to the majority. That's something amazing. I mean, the fact that recently there was an election in America and power passed from one person to another through an election is amazing. I remember when I studied family law, in the States, so the professor on the first day said that it's the 2 Ds. That's how a marriage ends, either death or divorce. And in terms of political rule, it's really just 1 D. It's just death. And that's if someone died because he was old, or you sentenced to someone, that's the only way you passed on rule. And basically, one person was given a great deal of power, and there was a notion that the majority should decide. That was a wonderful concept. It means, on this early view, that there's a competition between the majority and the minority. The majority wins. It's a straight competition, and whoever wins, wins. Under this view, the big aspect, or the contribution, I would say, of the first stage is much more that there is a recognition that the majority can decide. And the minority really wasn't viewed as that important. The second stage, which is more of a constitutional stage, I would say, is recognition that minorities have rights. This is something very important which wasn't understood to begin with. A lot of people, if you'd say to them, even today, what is majority? They would say, well, it means the majority rule, that what most people want is what is the law, is what the society decides. Of course, this is ridiculous if, so to speak, 51% of the population said we should kill the other 49% of the population. That wouldn't pass in any court, nor should it. And the reason is because that minorities have rights, and the rights are not only not to be killed. I'm taking an extreme example. Even in the area of company law, there's a recognition of minority rights in companies. So, of course, it should be much, much stronger when you're talking about the rights of the minority. And there's a recognition that minority rights have to be protected, and this is something that's very, very important. So much so that President Grunis was of the view in certain cases that he decided that for example, with the question of whether you should enlist Haredim, that you don't even have to get involved with that because the purpose of the court is not to protect the majority. The majority wants to injure itself, it's going to be allowed to. The purpose is to protect the minority. That's something which is very important to minorities everywhere. I allow myself to say that Jews, given their history, especially should be aware of this point, but it's something which, as I said, is a second level. The third level, which I think is the level that we're at now, we're entering now, and it's more and more becoming a factor, is that the minority not only has rights, but you have an obligation to have the minority participate in government. They have to be involved in government. It's not, this is sort of going back to the first stage, that there's an election, the majority wins, in 4 years we'll have another elections, in the meantime, minority, you wait, hope that there can be elections soon, but there's not for anything for you to do. And this started, and this is relevant to this case, in the committees, because it's something which is a function in many countries, and I brought the data, that minorities have to be on certain committees, which wouldn't happen naturally. They have to be on certain committees. In this committee, which is important, a minority has to be, a minority of parliament has to be involved, and it's the participatory democracy at its best. That includes not only the majority, but the minority as well. This is something which is very important and has applications. Why is it important? So here, I will mention reference to what I call the rights of the minority to participate in decision-making, an extra-legal view. And as I said, I think it's important to look outside of the box of law to better understand this. And here, I will state what was brought by Professor Waldron, and the following things were said by him. As he put it so well, he says as follows: the democratic process is not only a procedural process that offers an efficient means for decision-making, but a process that expresses the substantive principle of equality and mutual respect. The basic presumption of a democratic concept as the purpose of political decision-making is not the achievement of absolute truth, but the choice between competing legitimate worldviews. The underlying presumption of a decision by the majority is that given human variety, disputes are unavoidable, and a just decision cannot be defined per se. And now I quote him directly, but I think we can say more along the lines of what I call the physics of consent. Majoritism is not just an effective decision procedure, it is a respectful one. Respect has to do with how we treat each other's beliefs about justice in circumstances where none of them is self-serving, none how to treat the truth about justice itself. It is because we disagree about what counts as a substantially respectful outcome that we need a decision procedure. This is quite fascinating because of the fact that kavod ha'adam, human dignity, in Hebrew the word kavod means both dignity and also respect. It has a dual meaning, and it's important to understand that we're not having a pro forma discussion, let's talk about it, let's vote. You have to really respect the other. You have to realize, I think it's at the essence of law. One of the amazing things about law is there are no right answers. It's like when I studied arithmetic in 4th grade, I was very annoyed when I found out that the teacher had not only the same book we had, but at the end, the teacher had all the right answers. Why did she have it? I need the answers. There's no book like that when it comes to law. There's no book like that when it comes to politics. The answers are very hard. Things can be right in one country, wrong and different in a different country. Time can change decisions. In 1960s, in the 60s, the American Supreme Court said that interracial marriage is disallowing or forbidding interracial marriage is forbidden. Why was it forbidden in 1967? Why not in 1957? Why not in 1977? The recent decision of the American Supreme Court about homosexual marriage, they could have decided it 5 years ago, they could have decided it 5 years from now. This is what is important. This is what what Professor Waldron writes about, drawing on philosophers, primarily Locke, Kant, and Aristotle. And this is something which is very, very important. And here I bring and note the parallelism with Jewish law. The parallelism with Jewish law is quite striking. In Jewish law, the view is that if the Sanhedrin, the legal body, the supreme legal body, does not have a discussion, does not have a debate, then the rule is not binding. There must be a discussion. And what's interesting, and as justices, and I'm sure Justice Meltzer will bear me out on this, they have wonderful procedural rules. For example, if you sit in a panel, you ask the youngest member first, what do you think is the right decision? And anybody who's sat in panels know that very often, you can be a little intimidated in the beginning and it doesn't work and so forth. There's even a decision that if you have 71 justices, or we'll call them the rabbis that are sitting on the Sanhedrin, on the ultimate court, if in a murder case, every one of them decides that the person is guilty, the result is that he's innocent. Because the assumption of the Gemara is, of the Talmud is, that if no one can find a view, a way of finding him innocent, then there's something wrong with it. If you cannot recognize that there's another view. It raises an interesting question that rabbis ask, because they think very Talmudically, what if I'm the last person and everyone so far has said that he is guilty, and I think he's I think otherwise, and I think he's guilty. If I say he's guilty, he'll be innocent. So actually I should say he's innocent to get the result I want. So the rabbis dealt with this question and said, no, you have to give your real answer. So seriously do they take this question. The Rashba, who was in Spain in the 11th and 12th century, talked about the fact that you have to have a discussion, and if you don't have discussion, then you have not made a decision. Putting it even in a firmer way, the view is that certain decisions have to be made in public affairs, it's rather interesting, have to be made by everybody. Now, how could this possibly work? So the rabbis explain it has to be made by everybody in the sense that everybody has to agree. What does it mean everyone has to agree? It means that the minority, if it's given a chance to present his opinion, he agrees to accept the decision of the majority. If you don't let him have his opinion, then he is not agreeing, it does not bind him. Only the fact that you've heard what he has to say. And I think, and this is very, very important in Jewish law, that there's a point which is very important, that there's a discussion between the great Talmudic scholars Hillel and Shammai, and they disagreed on about everything. And the Talmud says that, and this, what I'm going to say now, to my mind, is perhaps the most important thing I'm going to say, that they're both right, they both reflect the word of the living God, but the law is like Hillel. And why is the law like Hillel? Because Hillel was tolerant, because Hillel, when he would state his opinion, he would first mention Shammai. Shammai would say, this is what I think the law is. Hillel would say, Shammai says this, but I say this. And it bothered me for many years. So what? Let's say I'm sitting on a case, and I'm sitting with Justice Meltzer and with President Naor, and I have to decide. And let's say I'll favor him. I think that his character traits are fantastic. I think he's a person that I should follow and learn exactly how to act. Is that a reason in a particular case to get to agree with him? Even he wouldn't say that. And now we're talking about divine law. So why is that a criteria? It's nice. Hillel did something very nice, but why is it, what relevance does it have to law? And I think the reason is because if, when you state your opinion, you begin by stating the other person's opinion, the way your opinion will change. Your opinion will be more nuanced. Your opinion will be more broader. And this is really what the importance is in deliberation. So therefore, and with this, I'll end on the case so we can talk about the other case. In this decision, I mentioned that, first of all, you really have to have a real representative of the minority in the city, municipality, and the person they picked was not the right person because of the fact that the majority doesn't get to pick the representative of the minority. The minority should be picking the person, that he was really in many senses not really in the minority, and therefore that was a decision that was made. The second decision, I'll run this by a little faster, has to do with the Lapid case. Lapid is, as you know, the head of the Yesh Atid party. This is a very fascinating conversation where Justice Meltzer caused us a lot of trouble in his opinions. And what happens there was the question that he mentioned in a decision that the previous decision which he sat in said that there was the religious parties, they didn't want to take responsibility for being in the government. So what they said was that they will be they didn't want to be a minister because it shows that they're really totally a part of the government, so they wanted to be an assistant minister with the powers of a minister. And the court says, basically, the court decided in that decision that there's no such thing and you have to stop with this kind of thing. And then the case came up regarding the prime minister. And the prime minister was, at that time, he was the one who held the minister of health, who was previously the assistant minister, and we made him a minister. He said on TV that he was grateful because he made more money now because of us, because his salary went up from being an assistant minister to a minister. And Justice Meltzer said that, wait, there's a problem here because of the fact that can the prime minister hold 5 portfolios? Can he be a minister of so many things? Maybe it's a problem in itself, regardless of this issue. This was discussed by the court. Reading the decisions, you can sense that there's a lot of disagreement to what extent the court should be involved in an issue like this. Justice Meltzer was of the opinion, in a very well-reasoned decision, that, without going into it, why it is not correct to view this as a possibility. The president, Naor, was on the other side of it. And the middle group, which I was a part of, felt that what's important is that the issue should be resolved, that basically perhaps Justice Meltzer is correct, and we gave what we call the warning. Not a green light, not a red light, but a yellow light, as I wrote in the decision. And we said that you cannot continue doing this. Why did this bother us? And I think that what's important in understanding this decision is the fact that, and I quoted Thomas Jefferson, the third president of America, on the question that there should be rules, there should be clarity. It can't be an issue like this is not defined. That somehow we have practice without, if they want to decide this, then I'll deal with the constitutionality of it. But because it's done, because it can be done, because the minister can appoint, the prime minister can appoint, doesn't give rise to the dignity of legislation. If legislation is treated as some sort of game where you can change the rules as you go along, as if it's some kid's game and I'm losing, and say, okay, now I'm going to do this, now I'm going to do that, then you're not treating legislation with dignity. And not treating legislation with dignity is ultimately not treating people with dignity. Because the power of government is so strong, it has to be dealt with in a way that reflects our desire to achieve human dignity. And here again, I referred to also Joseph Raz, who you quote quite extensively, and also to Professor Waldron in terms of the importance of understanding how important it is. He said that the institutions of legislation, quoting you again, should be viewed as a dignified mode of government, a respected source of law. In view of the permanent lack of societal agreement on certain issues, decision making by means of an elected body is not just an effective decision procedure, it is a respectful one. Note the language. we can pick whoever we want to quote from. That's what's fun about Israel. We don't have a debate in America about, Kennedy versus Scalia, may he rest in peace, whether we should be involved with comparative law or not. And this was picked because the tone is very, very constitutional. The tone really raises the level of a discussion to a different view. And therefore, if you talk about the need to have respectful legislation, pay attention. We're not telling the court or the legislature what to do. We're just saying, if you have this power, if you have this position, then give it dignity. Respect yourselves. Respect the responsibility that you have been given. And based on this decision, I said that we will give 8 months for the Prime Minister to decide what he wants to do. I don't have to explain it to you. I'm sure you can understand that this is not exactly what you want to do in the court, to have this kind of confrontational aspect, but we felt, and because of Justice Meltzer, I was sort of a moderate. I wasn't even that extreme, because he was more extreme. So it's another reason why it's good you're on the court. The issue then was said the 8 months, somehow the time has passed, and basically now there's just one portfolio which does have some basis, and I won't go into the theoretical aspects of that. So I will stop here. Again, I just want to reflect that this is an interesting example of how a great theorist, a practical thinker, was incorporated into Israeli law as a means of not only making a decision, but also hopefully directing the course of how the legislative body is viewed. That the problem is not piecemeal. It's not to say, well, here you should have done this and here you should have done that. You have to raise the whole level of how government views itself. And I think the concept of the dignity of legislation, the realization that the democratic process is a deliberative one, that it's very hard to say, I have the truth, that there's no way to know. So the best we can do is well-intentioned people debate, discuss, present their issues, listen, and then decide. And if that's not being done in a real way, then the courts should try and direct them to do this. As I said, I'll stop now, and feel free to respond. Thank you.
Thank you very much indeed. So Justice Hendel, Justice Meltzer, Mr. Dean, colleagues, it's an honor to be here and to reflect on these matters. It's an honor to find that the writings on the dignity of legislation have been taken up in exactly the spirit they were offered, and so I'm most grateful to that. I want to speak a little bit about the two cases that Justice Hendel has mentioned, and I want to talk a little bit about the overall theme of the dignity of legislation. Do you remember the two cases involve the representation of minorities on committees of municipal government on the one hand, and the second case has to do with an apparent gap in the rules determining which ministerial portfolios, if any, can be held by the Prime Minister. In the first case, I thought that the analysis that Justice Hendel gave was exactly right, that we need to think about the relationship between majority and minority I believe in three ways. One is that we have a procedure which is called majority decision. I'll say a little bit more about that in a moment, whereby when there is disagreement in a community after a period of deliberation, we effectively count heads, and the decision goes with the most popular option. We do this in court. 5 votes defeat 4 on the US Supreme Court, and on any of the panels in the Israeli High Court, I imagine the same thing happens. It's a simple majority. Question about why we do that, and I've written about this, but that's another matter. But we do this in a way that is respectful of everybody casting a vote. Each vote is counted, the votes are counted equally, and we know that there is no procedure. There is no procedure available which satisfies the conditions of giving each vote as much influence as it can be given, consistent with equality, making sure that each vote counts in the direction to which it points, treating the votes as equal. There's no procedure except majority decision that satisfies those intuitive conditions. So that's the first thing that we do. The second thing that we do, and here the court does very important work, is protect the position of minorities against oppressive laws, against the tyranny of the majority. And there's lots of things to say about that, but tonight is not the occasion to say them. Because what we're interested in, and I agree with the Justice, that this is a further elaboration of respect for minority, is respect for minority participation and respect for the role that minority members, particularly in structured institutions like legislatures or municipal governments, the role that they play in the public affairs that are committed to the charge of the legislature or the municipal government, the role that they play, notwithstanding the fact that if there's an up or down vote on some matter, they may lose. But we expect that minority members will be members of committees. We expect that minority amendments will be accepted and considered. We expect that minority concerns will be heard and attended to. And we therefore are committed to being able to say to members of the minority and those whom they represent, we know you disagree with this measure, but you can see your participation in the measure. You can see the role that you played, because the whole point about political legitimacy is to try to secure acceptance, honouring of a decision, even by those who are opposed to it on its merits. One way is to emphasise simply the fairness of the procedure. One way is to emphasise that there are constraints on how oppressive the measure can be. But now we're talking about a third way, which is that the minority can reconcile themselves to a measure by seeing the role that they played in the drafting and setting it. And I think with you that third mode of respect is tremendously important. Notice it works only because we don't have plebiscitary politics by referendum or popular vote. We have politics with mediating institutions. And we set up institutions that enable us to give minorities these different roles, both at the legislative level, at the municipal level, and at the subsidiary level where committees are being entrusted with certain work. One of the things that I wanted to emphasize in the dignity of legislation, and also in another book called Law and Disagreement, which appeared in the same year, 1999 sounds about right, was that with legislation, we set up an institution embodying large numbers of people. With courts, we don't. We set up courts with, the Israeli Supreme Court has 15 members and sits in panels of 3 or 5 or 11 or whatever. Relatively small number of deciders. In legislatures, we set up, the Knesset has 120 members. The Congress of the United States, with its 2 houses, has a total of 535 members. Yeah? We set up legislatures in their hundreds. And we set them up because setting them up in that way makes sense only because we value diversity. Otherwise, if we just wanted all the members to be the same, we could just have 1 member, or we could have 10 members. But we value diversity, we value political diversity. And so we have schemes of proportional representation, even of minority parties. We value, less formally, ethnic, gender diversity. We value diversities of religious parties and non-religious parties. We want to make sure that the legislature of a country is a country where all the voices in the community, all the distinct voices in the community can come together and be heard. Now, it's not always perfect, but one of the great virtues of legislatures, with their hundreds of members, is that they are the place. The cabinet is small, the court is small, but the legislature is the place where we pay tribute and accord respect to the multiplicity of voices to be heard in the community. And we expect the legislature to do its work, its drafting work, its deliberative work, its technical work, and finally its voting work against that background, acknowledging that there's disagreement among an array of people who are not necessarily all on the same page with each other. And this is very important when we come back to the issue of legislative procedures, about which I want to say a little bit. in a moment. But it's very important that we set up government, even municipal governments, they may have, a panel of 25 people and then small committees of 8 or 9. We set them up with a number of places, a number of chairs at the table. So if need be, those chairs can be filled by a variety of persons. So that, going back to this point about legitimacy, when a measure is passed, whether it's a decision, a tax decision on a particular exemption, or whether it's a particular measure in the legislature, it can be said not only that we respected minority votes, not only that we respect minority rights, but we respect minority participation. And I do think it's very important. Now, I believe that this same aspect of modern legislatures and of governments generally, the plurality of persons, the large numbers of persons, makes a difference also to procedures, both constituent procedures that establish the basis on which the executive, the cabinet, is formed out of the Knesset, out of the parliament, and the procedures within the legislature itself. It's important that those procedures be defined. It's important that those procedures be clear and that those procedures be formal. Of course, people have conversations. They have conversations in the corridors of the legislature. We've heard already conversations back and forth between Justice Meltzer and Justice Hendel this evening. But it's important that for the decisional aspect of deliberation, that the procedures be formal. And that, I believe, I take this a step further in the law and disagreement, it's important that the text be formally defined. And to that extent, a follower of the late Justice Scalia in his notion of textualism. It's important that the procedures be relatively rigid and relatively formal. Why? It goes back to this question of diversity. We're not talking about a conversational club where people can say to each other, come on, you know what I mean, yeah? Maybe some members of the Knesset can say that to each other, but yeah. But normally if a member from one extreme faction says that to somebody on the other side of the house, the person will say, no, I don't know what you mean, yeah? I'm an Israeli Arab, you're an Israeli Jew. Tell me what you mean, explicitly. People need to spell things out and formalize things when there isn't the basis of common experience to draw on. And since we value the diversity of legislatures, since there would be no point of setting up these institutions with their hundreds of top echelon members, unless we valued the diversity, we've got to value the conditions, the rules, the structures, the formalities that make possible people who are strangers to one another to talk with one another. Of course, we also want those rules to provide a basis for mutual civility and mutual respect. So everybody knows whose turn it is to talk. And everybody knows who may interrupt if interruptions are permitted. And everybody knows who may demand an answer to a question and how quickly an answer must be given. We have that in court too, even more intense focus on procedure, because we have two parties who are at each other's throats and the need to be able to talk to one another in front of a common tribunal, and they can't just be screaming at each other. So we tightly script. So I believe very strongly in this element of formality and formal procedure. And I agree that it follows from this that the procedures have to be relatively tightly defined, and that we should be very concerned about situations where important aspects of what might be the procedures are left undefined and have to be inferred from underlying principles. But notice, there's a kind of attention in Justice Hendel's presentation, because I think he believes two things which I also believe. One is it's important for procedures to be relatively formalized and tightly defined, but on the other hand, it's important also to understand why that is, which means understanding deeper principles that underpin the role of procedures, and deeper principles in the case of the representation issue that underpin the very idea of representation and respect for minorities. My mentor was a man called Ronald Dworkin, and he was, until he died recently, my colleague at NYU, And he taught me that law consists not just of surface-level rules and surface-level cases, but of deep background principles and policies. And you can't understand the cases and the rules unless you understand the deep principles that inform them. So it leads to a kind of a paradox when it is the deep principles of understanding the legislature that call for determinate rules at the surface level. Now, I wanted to say a couple of other things. In all this talk about diversity and minorities and majorities, in all this talk about representation and decision-making, I have been assuming, as Justice Hendel was assuming, a broadly majoritarian framework. But I would caution against any view that reifies the majority, that talks about the majority as though it were a thing or a distinctive population. The fact is we are individuals, men, women, and children. And those who disagree in a political community and those who have different perspectives and beliefs in a political community are individuals. There are similarities between them that enable us to talk about the majority opinion on this or the minority, a minority, or multiple minority positions on that. But majority rule does not, or certainly majority decision, does not involve a commitment to find something called the majority and give it power. Majority decision means that on every important issue of government, the matter will be decided by respectful voting among individuals who themselves have their position as elected representatives on the basis of respectful voting among individual citizens. We talk about majority rule as a decision procedure, but if I had my way, a lot of the work of Rousseau would be banished, from political theory, because we're not trying to find something called the general will and empower it, nor are we trying to find something called the majority and give it power. What we have, there's nothing but us individuals in the room, and what we have is our procedures. We organize ourselves into parties for very good reasons, many of which are being unfulfilled in modern American politics because of the decline of political parties. We organize ourselves into parties because we want people to understand the diverse perspectives that can be had on the issues of public affairs, and also understand, by participating in parties that are preparing themselves for government, how a variety of policy issues relate to one another, both fiscally and in other dimensions of interrelation. So party politics is a very good discipline by which individuals may mediate their involvement, but ultimately it's the individuals we care about. The individual citizens ultimately who elect the representatives, and the individual representatives who in their diversity provide a basis for representing the diversity of social positions, political positions in the society. So when we have a majority vote and 5 people raise their hands and 4 raise their hands against it, we don't bind the 5 together and call it the all-powerful majority. We say, okay, we've decided that issue. And maybe, you see this in court all the time, a different majority will form on the next issue on the docket. Now, I wanted to say just a few final things. I do agree, probably more than I can convey, with the emphasis that Justice Hendel has placed on the importance of respect, mutual respect, within a legislature. I believe it's important in courts. I believe also it's important at the level of cabinet government as well, especially in coalition government, where there has to be some respect among parties who often hold quite opposed views, even though they are members of coalitions. The notion of respect is important, and I think if we respect the legislature, we partly respect it because it is a respectful setting. It is a place where people respect each other. We'll talk about this more when we talk about dignity in half an hour or so. But I believe it's important for us to understand that this respect can be lost in various ways. I was born and brought up on the other side of the world in New Zealand, which is a country geographically bigger than Israel, but smaller in population, of about 4.5 million people in a couple of islands about the size of the British Isles, much of it uninhabitable. And what has happened there, it's a unicameral society, like the, unicameral legislature, one house, just like the Knesset. What has happened there is that in the name of legislative efficiency, attempt after attempt has been made to reduce the mechanisms and the procedural formalities of legislation. They decided they don't want the members sitting around talking, they want them to get on with their work. So they were to be given shovels and sent out to mend the roads. The outcome of each vote, because it's a broadly majoritarian country, is well known in advance, so what's the point of having a discussion? The government's measures are going to be passed anyway by virtue of its minority. Recently they established that members don't even need to be present in the chamber to vote. What happens when there's a division is that the whip for the Labour Party calls out the number of Labour votes, and the whip for the National Party calls out the number of national votes, and the whip for the New Zealand First Party calls, and there might be 3 people in the chamber, and the vote is taken. So every time I go back to my homeland, when I talk about the dignity of legislation, I talk about it in sad and reproachful tones. I think the dignity of legislation, the other point I'll make and then I'll stop, the reason why I wrote this book, apart from vanity, was that in the United States particularly, in United States law schools, which is my habitat in New York, there is a great deal of admiration for the Supreme Court of the United States, and law professors fancy themselves as people who sit behind the chairs of the Supreme Court chamber and whisper things in the ears of the justices. And students are taught to understand the dignity of the court and what it does, particularly the second function that I mentioned, which is the function of upholding individual and minority rights against oppression. People understand the dignity of the procedures of the court. People understand the dignity of the reason giving and the argumentation of the justices. And when that comes to the vexed and difficult question, how do you justify, by a vote of 5-4 among 9 unelected and unaccountable justices, striking down legislation, because the US Supreme Court doesn't even have the mechanism of putting the legislation on probation or anything like that, striking down legislation when that legislation has been supported by a majority of legislators in 2 houses and a majority of citizens who voted for the legislatures. What they say is, well, have you seen what happens in Congress? They say it's a zoo. People are screaming at each other, and many of them are corrupt, and they take no notice of each other's speeches, and some of that is true. It's probably true in the Knesset as well. I've just come from, last week I was in Brasilia, of all places, and I think 300 members of the Brazilian Chamber of Deputies are facing indictment for corruption. So people say, have you seen what happens in a legislature? Of course we want to have decision-making by the court. And so they give a perhaps realistic, perhaps exaggerated portrayal of the antics and the misbehavior of the legislature, and they compare that with a very rosy and dignified view of the court. So I wanted to write the dignity of legislation to correct the balance. I want to say, okay, if you're going to give a rosy understanding of courts and adjudication, which is a very good thing to do, then I'm going to match that with a rosy and dignified account of legislation, at least of legislative aspirations, but I hope, as I've set them out, they are realistic aspirations. I say, I understand that you can give a very discreditable view of legislation. I said, there's a few secrets I can tell you about the court as well, yeah? But let's compare like with like on this. And let's make it clear that the dignity of legislation is a deeply rooted idea because of its character as a structurally respectful institution. So I much appreciate the fact that some of these ideas are being taken, but I've learned as much from this presentation as you ever learned from this book. So thank you very much.
Thank you. We'll now do our second round. We plan to have 2 rounds. Thank you. It's interesting what you say, because when Justice Meltzer, I'll tell you an inside secret, when we sit together, sometimes I say on an extended panel, do we have the 5? Do we have the five is an American, we do this.
That's right.
Is an American expression because there are 9 people, and if you have the five, you have the five. And it's very interesting because in Israel, the panels aren't always the same.
Yes.
And so it's a question because it could be a different panel, might have reached a different decision, and raises all sorts of questions. But I'll make a few points. And first of all, I want to talk about a case which is interesting in terms of the importance of hearing the minority view, which was an Arnona case in Eilat. An Arnona case in Eilat, that there's a panel of 3 that decides the Arnona appeals. And
what's an Arnona?
Arnona is a civil, you pay a certain municipal tax or levy.
Sure. Right.
And what happens is that what happened was that they came before me, and there were only 2 people that decided. There's supposed to be a panel of 3. Eilat is far away. There's a beach. There's the sun. They said it's very hard. You need experts, accountants, and so forth. So what we do, they explained to me, is we have 2 people sitting on the panel. I said, but it says 3. He said, no, don't worry. You have to understand, if the 2 people don't agree with each other, then we bring in a 3rd. So what's the problem? So argued the state's attorney. Now, what I wrote in that decision was based on a Jewish law, a question which says that the purpose of having a minority, of hearing different views, is because the minority opinion is not only there, the 3rd person is not only there because then it'll be 2-1. If you respectfully listen, he might persuade the other 2 to change their minds. Yeah. And this was based on a principle in Jewish law. And Jewish law also says that why the minority opinion is written in the Talmud, because perhaps in certain situations it'll be accepted. That was the first point I made. The second thing, I was struck by what you said, talking about the dignity of legislation. If as a judge, I may say something about the dignity of the court. And one of the things that I must say moves me very much, and why I think the court works, and why to some extent, courts all over the world, there's a respect. I think about it when I hear difficult criminal cases, and there's someone that since he's 16, he's been in and out of jail, and he comes to court, and all of a sudden a justice calls him sir, speaks to him with respect, says, I want to hear what you have to say, listens to him. It's very powerful. It's a very powerful thing. It's an experience which I don't know if he had somewhere else, and it's one of the most wonderful things about a court. Having said that, we'll get to Israel, because some of the examples you gave, I smiled at them. What do I mean? I practiced law in New York. Now, when you practice law in New York, when you make a summation, when you summarize the case, sikumim in Hebrew, you listen to the other person. You don't interfere. One time, in all the years I was a lawyer in America, I interfered. I thought the judge was going to shoot me on the spot, and I had 8 sources, cases to explain why this was an exception. I said, okay, you have an exception, but don't use the exception again. And there are rules, even unwritten rules, how long you argue, let's say in an appellate court. They have 15 minutes, there's a green light, a red light. And if someone says to me, how long do you let someone argue in an Israeli case the truth? I have no idea. It depends a lot on you. You know, if you're making sense, then I'll keep going. If I have to keep, so if you have 6 points, don't give me the bad points in the beginning. You won't start with your strong point. And it's a very informal type of situation. I mean, you watch, I assume, sometimes on the television, the Knesset and the way people interfere, and even the court process is a lot less informal in terms of people interfering, and one person, it's a problem. And there's a certain, I would say, what we use the word chen, a certain graciousness about it. It has a certain charm to it, but it's a problem. And this raises a certain question which I think about a great deal. I know in your works on judicial review, you're skeptical of too much judicial review, which I agree with. But one of the things you write, that in certain circumstances, there may be a need for more of a judicial review. And one of the interesting questions about Israel, and I raise it as an open question, the whole idea of a constitution, the whole idea of the court saying that laws no longer exist because it contradicts a principle, is something which takes time for a society to accept. I remember when I learned constitutional law in America that 50 years after Marbury versus Madison, which decided that there's a right of judicial review, it was very much in dispute whether they had the right to do that. It's not in dispute anymore. One of the most touching things about America, moving things about America, is that people really believe in the Constitution. Someone on the ultra-right or the ultra-left will agree with the Constitution. They view the Constitution differently, what the result should be. In Israel, we're at a different point. And I was thinking about that, perhaps you want to remark about that, how that affects the situation, how that affects how much a court should be active or not active, and those types of questions. And to me, that's a very real question. I think that the court has to be especially sensitive to what it's doing, and it has to sort of work at a reasonable pace. You know, there's a thing that, the expression that they say that if you're, one step ahead of everyone, then you're a genius. If you're 3 steps ahead of everyone, you're a madman. And so you have to really work with, especially in these kinds of cases. I'm not talking about a criminal case. A criminal case, if you think someone is innocent and everybody's convinced he's guilty, you have to find that person innocent. And if you can't do that, then you shouldn't be a judge. Yeah. However, when you're talking about, as I mentioned before, because time is a 4th dimension in law as well as space-time. And by that I mean that you have to work within a process and you have to move things forwards. I also think, and perhaps you could comment on this as well, with the American experience, because on the one hand the Constitution is very strong, but sometimes you think that maybe it's a little weaker now. And one of the advantages, I think, of the Israeli Supreme Court is that while they now have some sort of mini hearings based on the American Senate experience when they have hearings for judicial, for Supreme Court justices, people don't really know what justices think. To be honest, some justices themselves don't know what they think about certain issues till they have to decide it. And a court where basically the results are predictable, and it be a question of who's the 9, sure. If this president can appoint 3, it raises questions with all the respect that the Supreme Court has, and rightly so. So that's a question. Whereas on one hand, I wonder about where Israel is now, and also where America is, even though they're basically 2 different questions. And I think one of the problems, and with this I'll let you respond, is consciousness. I wrote in a certain decision that one of the big differences between the way somebody thinks in the 21st century and someone who thinks in the 16th century, we have much more consciousness. We have consciousness of consciousness. People talk in a way that they didn't talk before. Freud had a major, major effect on how psychologically we speak and how we view things. And the processes, the legal process, legislative process, they're naked. And people are aware of it. And people respond to it. And you have this tension. And the question is, how does that affect goals of achieving dignity in legislation and dignity in court?
Good. Thank you very much indeed. So there's a lot to think about there, and some of it is conditioned by the point that what I said earlier about legitimacy applies as much to decisions by courts as it does to decisions by legislatures. There has to be a way. There has to be a way rooted in the status and perhaps the procedures and maybe the charisma of the court, maybe just its dignity as an institution. There has to be a way of reconciling people who oppose the judicial decision to the judicial decision that it's laid down, particularly because courts do not have armies of their own. They don't have the power of the sword. When a court makes a decision, it relies intensely on the fact that other agents within the constitutional structure, however grudgingly, in the case of President Trump, will abide by the court decisions. And that means there have to be features of the way the court operates and features of its relation to the Constitution that help to make that decision-making legitimate, at least for practical purposes. And a great many theorists in the United States, as Justice Hendel will know, have worried about the conditions of the legitimacy of the court. Particularly, they're worried about the point that he made, that if it becomes to be widely perceived that the decisions of the Supreme Court of the United States will change every time there's a change of personnel, every time there's a new appointment on something like abortion, then people will begin to think that they're being ruled by men and not being ruled by laws. And this was laid out by the plurality discussing respect for precedent in Planned Parenthood against Casey, which was the great abortion decision from 1992, sounds about right. My wife is a law professor at Columbia, and she writes about abortion, so I know about this stuff. So the court has to maintain, in some sense, its status as some sort of objective decider. It has to maintain its connection with a constitution, which, as Justice Hendel said, is a constitution that is widely revered across a whole political spectrum. The people in the United States, they own the Constitution. Yeah? Some of them carry it around in their back pockets, and they pull it out at family barbecues that argue with liberals in the family. They say, where does it say in the anything about abortion in the Constitution? People, I mean, and it's a short document. I was in Brazil. The document is about 100 pages long, but the Constitution of the United States, even including the 28 amendments, is not much longer than a student seminar paper. But people own it, and that makes an immense difference. And as the Israeli people move eventually towards a codified constitution, bringing the basic law and giving it constitutional status, I think that is tremendously important. And any solution, long term, to the difficulties with the West Bank and Gaza will have to have constitutional status, and will have to, as it were, secure that degree of assent. Because if you live in a community which is massively divided on the Constitution, then it's necessarily going to be massively divided on the legitimacy of what the Supreme Court is doing. Now, all of this is complicated, as the Justice said, by Sigmund Freud. In the United States, and you'll know this as well as I do, it's complicated by Jerome Frank, who was a New York lawyer and then a New York judge, but underwent psychoanalysis and wrote about it in his book called Law and the Modern Mind. And he said we have to understand the thought processes and the instincts and the experiences that govern the hunches that judges and justices form when they're listening to arguments and listening to evidence. Yeah? True, they eventually go down and write out an elaborate essay supporting their position, but the real moment comes when in response to some event in the courtroom, a couple of neurons fire, and the judge then does his legal work in pursuit of that hunch that has happened in his head, which is going to be a complicated product of childhood toilet training and who knows what else. So Frank wrote about this iconoclastically, but he pointed out that this is just the way that lawyers operate, right? When you're working in a law office, you aren't asked to find the solution to a legal problem. You are given a position, the position of your client, and you're asked to write an opinion that will support that conclusion. The dominance of the conclusion is important in the law office, and Jerome Frank thought it was important in the courtroom. Now, he probably exaggerated, but we live in a world, certainly in the United States, a world which is post-legal realist, where we have tried to unearth the psychological and social and political reality of what the courts are doing. We don't continue, I don't believe you do in Israel either, but in some jurisdictions, there is a tendency to continue to hide behind a facade of judicial objectivity. So if you were to ask a French judge or a Dutch judge well, we just decide according to the law. We look at the code and we find out what the solution is. I was once at a conference with many judges at The Hague, and after listening to 30 or 40 minutes of this nonsense, a Irish judge, bless her, put her hand up and she said, "Can we all grow up a little bit, please?" She said, in some jurisdictions, people have opened up their thinking about how judges decide. In some jurisdictions, they haven't. We can't talk seriously about French law or Dutch law until we have some equivalent of the legal realist moment. But it's a dangerous moment because we know that these decisions are being made by people and panels of people who are all too human in their decision making. And one of the important features of the dignity of adjudication is try to clothe our naked, shivering psyches, which Jerome Frank has uncovered for us. Try to clothe them in clothing that will ensure a degree of respect and ensure a degree of legitimacy. I think that's very important. I think the procedural aspects are important. They differ from jurisdiction to jurisdiction. In the Supreme Court of the United States, you have a fixed term of minutes for your presentation, but that can be spoiled by the justices constantly interrupting you with questions. People say about Clarence Thomas, why does he never ask questions? The answer is he respects the attorneys too much. But so we have that process of highly, almost like a liturgy with different opportunities for participation by different parties, and that helps to secure some sense of the fairness of the proceedings. And the other aspect of it, the other way we clothe, goes back to this point that Jerome Frank spoke about, the scathing reference to a little essay that the judge writes to illustrate his decision. I'm a great fan of the legal philosopher Lon Fuller. Used to teach at Harvard Law School. Wrote a lot about the rule of law in the 1960s. In a wonderful book called, in a wonderful article called Forms and Limits of Adjudication, he said, why do we ask judges to write these little essays? Why do we ask Justice Hendel to write this? Why not just find out what he's voting? We don't ask legislators to write. And the usual response is because we want the decision to be a reasoned decision. But Fuller's response is, well, be that as it may, we want there to be some assurance to the parties that somebody has been listening to their submissions. And it's as though this is a homework assignment by the justice to show that he was awake and alert and thinking on the bench and that he respected the arguments that were being made. He didn't just say, yeah, sort of looking at his watch and waiting for the moment of decision. And there's something respectful about that as well. So those are the comments that I had for this particular phase of the argument.
We'll now do the third round. There's an elephant in the room, and we'll touch it, which is that the dignity of legislation, we talked about legislation, we have to talk about dignity.
Yes.
And dignity, what is dignity, is something which we'll discuss right now. Before I say certain, I'm sorry, before I continue, I'll mention, you said that it's a small essay. This is the basic law of Israel, human dignity. This is the extent of it. That's the whole.
That's it?
That's it, yeah. Now, there's something very interesting because different, as you know, different legal systems have different views. For example, in German law, so human dignity is viewed as something absolute. There's a price you pay for that because then you define human dignity in a more narrow way. But when we talk about basic law, human dignity and freedom, it means that Israel chose, for various reasons, political and otherwise, to put human dignity that's the standard. That's the standard. And the purpose is, the first paragraph is the purpose of human dignity says the purpose of the basic law is to protect human dignity and liberty in order to establish in a basic law the values of the state of Israel as a Jewish democratic state. So you see the Institute for Judaism and Democracy is something which is a legal term. I mean, it's something which you have to take into account. Then there are various rights that are mentioned. I just want to show you, and I mentioned this as something I wrote about in a decision recently, how different say the Constitution of American law is than Israel's Constitution. I'll take one example. There is, the law says that there shall be no restriction of a liberty of a person by imprisonment, arrest, extradition, or otherwise. Which, of course, is not true because Israel does arrest people. But then they say this is subject to law. That's it. Mm-hmm. That's the criminal law. Compare that to the Fifth Amendment, which talks about, as an amendment, as a constitutional provision that says that a person is not obligated to testify himself, the rule against self-incrimination. In Israel, you derive it because it's part of human dignity. So in some sense, what we're doing is we're raising human dignity as the key, as that will open all the doors to constitutional discussion. It's a very exciting period because of the fact that it gives the Supreme Court justices and the society a chance to evolve. But it's a certain kind of document, and that makes it all the more important to define dignity. What is dignity? Well, the problem is, and I'll be childish here, and I'm not just picking the word childish, I mean it literally. There are legal terms, philosophical terms, that are wonderful, and we know they're wonderful because of the fact that children use them. A child will say, use the word freedom. A child will say, we use the word right. A child will have a recognition of property. I have a 4-year-old grandchild, and when he comes and he wants to take the ball and I want to take it back, he says, it's mine, it's mine. And when I wanted to see how he responded, okay, I'm not the best grandfather, I admit it. He had some food in his plate, and I took a little bit of the food just to see how to respond. He said, it's mine. I said, why is it yours? So he said, I brought it from my house. I said, Grandma made it 10 minutes ago. How did you bring it? It's mine. So I'm saying there's a certain recognition of property rights. There's a recognition of freedom. People talk. There's a recognition of rights in general. Does a child ever say, it's my dignity? Does an adult, we talk about autonomy, does an adult in conversation who's not a lawyer, a judge, or a professor of law ever use the word, it's my autonomy? We use terms that I don't know how successful they are. In other words, dignity means something. What it means, I'm not even sure in conversation we know what it means. We don't say, you're offending my dignity, which is different than saying you're hurting my feelings. People say all the time, you're hurting my feelings. They don't say you're offending my dignity. I mention this because the vocabulary that we use is not easy. These terms are sophisticated. These terms are very important. But what do they mean? And that's something which legal systems all over the world have to grapple with. And when are you offending my dignity? What does it mean? We have some notion. Dignity, apparently, if you embarrass someone, you're offending his dignity. That doesn't mean that you're not allowed to embarrass someone, that it's against the law and it's against human dignity. So these things have to be thought about very well. And you also have to understand that when the court is deciding, the Knesset passed the human dignity law. It wasn't the justices of the Supreme Court. It wasn't Professor or Justice President Aaron Barak. This is the law. We have to do something with this law. We have to define it. I'm not apologizing. I'm not explaining. I'm just stating a legal fact of our system. It's the law. If we want judges to follow the law, this is the law. I have to preserve human dignity. What does it mean? Now, there are different concepts, and I think, and we talked about this before, that are sometimes confused. There's a question of human dignity. There's a term, freedom, a free choice, and there's autonomy. In the Ben David case, I talked about the fact that's a tort case where you now have a cause of action where you can sue as an infringement on human autonomy. There was a case a long time ago. What happened was that in a hospital, someone had surgery. They didn't ask the patient. The surgery was successful, so how was he hurt? He was better off. So they developed a tort of an infringement on human autonomy. What is human autonomy? What is it? I think that autonomy on some level is the right to choose. That's the way I understand it. That's the way I think Kant I'm simplifying it, and it should be expanded. There's a very interesting, by the way, law that Maimonides brings based on the Talmud, which is that, let's say I have a tree that's going to my neighbor's yard, and he tells me about it, and I said, I'll take it down in a few days, because the law, even in the Talmudic time, was that you had to take into account your neighbor's concerns. And he takes down, another neighbor takes down the branch that is going to the other neighbor's yard. I can sue him. Why should I be able to sue him? It's a very important question. I discussed it. What happened? I mean, I'm supposed to take it down. He helped me. He should be suing me because he saved me time. But the view apparently is that it's a mitzvah, it's a positive commandment, and you interfere with my autonomy to do a good deed. So autonomy is something which has roots in Jewish law as well. There's a wonderful example. I'm sorry, I'll let you expand on this. In a wonderful lecture that's given by, which I saw on YouTube more than once, by Professor Waldron, where he talks about 8 different constitutional cases, and he talks about what I'll call, for a better term, the midget issue. There are certain places where there are competitions. Who can throw the midget further? And what do you do about this? Now, if, as you pointed out so well, if the issue is a question of freedom, the midget may want this very much. As we discussed before, it's even an infringement on freedom of occupation. Very hard for them to get work. They're paid very, very well. But our inclination is to say that we're not just dealing with your autonomy to decide. There are certain things which we won't allow you to decide because we won't allow you to be degrading. That shows it was a beautiful point by Professor Waldron in the talk, that there's a difference. But when we talk about dignity, I think we have to be very careful. What I can, especially in the Israeli system where it's evolving, There's a famous case where the Supreme Court decided that you cannot privatize prisons and give it over to the public sector. And I think one of the reasons for the decision is because we're very respectful, rightly so, of the dignity of the prisoner. And therefore, we don't want to take it out of the state's hands. It's a very interesting example, because you would think one of the judges, the only one that was a minority, said, well, let's see, maybe they'll do it better. And maybe they would do it better. I don't know. But the question is that the human dignity aspect takes place, takes priority. And I think one tool, when you're thinking about a human dignity case, I think you have to ask, is there another side to it? Can human dignity be used on both sides of the argument? And if that's so, be aware of it. Ask yourself. Don't just say there's just human dignity as well. And sometimes you have to prioritize. In some of my decisions, I have mentioned that I think that rather than having the balancing act, which was very developed by by Justice Barak, President Barak, I think we have to start grading or prioritizing different rights. And this is something which we can learn from the American system, and some rights are more important than other rights. But I think we have to ask those questions and not use dignity as a gimmick to justify our positions. You have to really deal with what dignity is. You have the question of, let's say, in tax law, whether it's a violation of property or it's not a violation of property. These questions have to be asked and they have to be dealt with. And we have to, I think, move forward with trying to define what dignity is and when human dignity is impeached. And it's something which judges and the society have to think about differently. It requires a different way of thinking. And I think that's something which is very, very important. The other aspect which is interesting is that we talk about it as the human dignity law, but it's actually the human dignity and liberty. Actually means, you could also define it, kvod ha'adam, human dignity, v'cheruto. Cheruto means, as if the context it's used on Passover, and freedom, human dignity and freedom. And I think sometimes that we overemphasize human dignity at the expense of freedom. I think very often when you're talking about certain kinds of cases, let's say freedom of movement, it may be more about freedom than about human dignity. It's about both. But sometimes I think we have to recognize certain criminal law cases, I think, are very often more about freedom than about dignity, even though they may be about both. So that's another point I would have to make. What I'm trying to say, that these issues are difficult, but we have to think about them, we have to address them. It's one of the reasons, going back to my fourth grade arithmetic teacher, I think that we have to see why comparative law is so important. I mean, it was interesting that, South Africa passed a law saying, or had a decision, the Supreme Court had a decision saying that capital punishment is against the dignity of a human being. America is a very sophisticated democracy. America has sense of dignity, and it doesn't talk the talk of dignity, which is also something interesting. It talks more of the rights and so forth. They don't have a problem with it. They don't see it as something unconstitutional. And I'm not saying, therefore, perhaps America is wrong. That could be one conclusion. But I'm just saying that the issues are very, very complicated, but I think what's important is to move forward, and to move forward with really testing both sides of the issue, and recognizing that that's what's special about people, that people have dignity. You've spoken about human dignity in God. From an Israeli perspective, if I may say that the notion of the Jewish state, whatever that means, does it mean just the people? I think it means something more, because I think there's a culture, there's a legal tradition. I think that there's a recognition which is more natural than other countries, that recognizes the Jewish aspect of human dignity. And the Jewish aspect of human dignity, I mentioned freedom, it's more connected with the Bible, it's more connected with God. I don't necessarily mean in a religious sense in the narrow term of it. I mean in a broader way of looking at it. I think, and this is a very difficult question, that human dignity means more if you believe you were created in the image of God. It doesn't mean that you can't have human dignity without that, but I think it's a different topic. So we have in Israel a special challenge when we come and we define human dignity. We have to isolate the term, we have to see how it's different, and we have to give it the proper value and the proper focus.
Thank you. Thank you very much indeed. This is enormously helpful, and again, we agree about almost everything, particularly about the work, the legal work, constitutional work that has to be done still on the concept of dignity. As a political and legal value, it remains a work in progress. And that work in progress has to be undertaken carefully and seriously, because evidently it's a serious work in progress. Dignity is evidently some concept that is supposed to measure and identify the momentous significance of each human being. The momentous significance of each human being, if you like, the high rank to which simply by virtue of being human we belong. The momentous significance of every human being and the implications that has for the way we may treat ourselves and for the way we may treat others and for the way we may be treated by the state. Beyond that, its definition still remains, as I said, a work in progress. People are unclear about how separate it is from the issue of autonomy. It's plainly not the same, and it plainly has a connection. About how much of a religious concept it is, for exactly the reasons that the Justice just spoke about. Whether it represents a return that some would say is unwelcome in secular politics to religious ideas. There's a question about how it operates in the multiple contexts in which it features. I sometimes try to get my students in my human dignity seminar to make sure that they understand what's in common between the use of dignity, say, in a death penalty case, and what's in common in the use of dignity, I don't know, in the dwarf tossing case, or what's in common with the death penalty case in the case of death with dignity, which is a phrase used to refer to possibilities of euthanasia. Because we have to understand that if we're going to define the term, it's going to be defined so that it has some, however abstract, some degree of constant meaning from context to context. It's also a concept that is being used all over the world. Basic law of Israel, the basic law of Germany, the opening principles and values of the South African Constitution, the French Conseil d'Etat in the dwarf tossing case, the midget tossing case, decided that dignity was an important aspect of public order, and it was entitled to close down exhibitions at pubs outside Versailles where dwarf tossing took place because this was an affront to public order. It's being used even in cases where it's not explicitly present in the Constitution, which is an example of the United States. Dignity is used all the time in constitutional adjudication, including, forgive me, in death penalty adjudication, when the death penalty was
Minor.
yes, in Furman against Georgia. The great Brennan justification of that referred to dignity all the time, and when the death penalty was restored a few years later in Gregg against Georgia, even those who were restoring it said it had to be administered in a spirit that would be consistent with human dignity. It was introduced into the Eighth Amendment context. You know, the Eighth Amendment prohibits cruel and unusual punishment. In a case called Trope against Dulles. Dulles was a Secretary of State. Trope was a man who had been a deserter from the army during the Second World War, and found when he got home to the United States, they refused to give him a passport. They said he had forfeited his citizenship. And the Supreme Court of the United States said this is a cruel and unusual punishment because it's an affront to the man's dignity. Human dignity requires that you have citizenship somewhere, and where else was he going to be a citizen? And it said that was the basis on which it got introduced. So, but it's in constitutions all over the world, and some people would say it's a kind of, this is the illiterate use of a physical term based on Star Trek, but it's a kind of a wormhole that enables different courts to make contact with each other around the world because they think they're involved in a common enterprise of human dignity. I think it's a tremendously fertile field, but we have to be very, very careful with it. Can I give you an example of this? In anti-discrimination law, what we often have to do is identify patterns of differentiation that the law requires, and law does this all the time. It says if you're in this category of person, you have these rights, and if you're in that category of person, you have those rights. Law does differentiation all the time. Legal systems in many countries engage in what we sometimes call affirmative action all the time. So it looks as though something which could formally be described as discrimination is part of the ordinary work of law. Anti-discrimination law wants to identify invidious forms of discrimination, nasty forms of discrimination. Forms of discrimination, as the South African Constitutional Court said, as the Canadian Supreme Court said until recently, forms of discrimination that are affronts to the dignity of the person who's discriminated. So in the Canadian context, a young lady was widowed, her husband died, and she received a widow's benefit. And the benefit she received at age 32 was very, very considerably smaller than a widow would have received had she been widowed at age 60. Yeah? And so she claimed this was discrimination on the grounds of age. And the Canadian Supreme Court said, well, it's certainly differentiation. But the reason why we give people a bigger widow's pension at age 60 than at age 34 is that at age 34 in the modern world, she can go and get a job and provide for herself. There's no insult conveyed. It says there's no affront to her dignity. She's not being told that she's a less worthy person. This is not like racial discrimination or gender discrimination or some notorious forms of age discrimination. So they established the doctrine that you have to pay attention to the dignitarian aspect of the differentiation in order to qualify it as unfair discrimination or as discrimination in the legally relevant sense. South Africans did the same in a number of regards. One interesting case where, I was going to say President Mandela issued an executive order freeing all men from prison. No, excuse me. An executive order freeing all women from prison who were serving a sentence of less than 14 years and who had children of a certain age that they had to look after. And a man called Mr. Hugo, who was a prisoner who had children of the same age but was a man, not a woman, claimed that this was discrimination, and the court had to decide whether this was insulting to men to pursue this possibility with respect to the discretionary release of women. South African court has persisted with this. The Canadian court, around 2008, decided that it would abandon this dignity test. It thought it was too much of a burden to require parties complaining of discrimination to show that their dignity was affected. What they would try to show was that this was a suspect category and there was no justification for it. It was a case where white Canadian fishermen complained about fishing rights being given to indigenous fishermen to fish for a particular species when the moon was full on a particular day of significance to the indigenous group. And again, the court wanted to be in a position to be able to say, this is no affront to the dignity of the white fishermen. This is just a special affirmative action protective measure for the indigenous peoples. But it decided that let's put the idea of dignity in the background. So we always have to stay open to that possibility that in the end the term may be not as much use as it appears to be, because it remains inherently controversial, because it may feature on both sides of the argument. In the United States case of Indiana against Edwards, which concerned the right of a defendant who was intellectually quite limited to defend himself in court. One side said it was an insult to his dignity to let him make a hash of his own defense. The other side on the Supreme Court said it was a insult to his dignity not to let him represent himself if he wanted to. How do you adjudicate between those two possibilities? I just want to take us back to this, not because it's got my name on it, but because we've talked about the dignity of legislation, and that associates dignity with an institution and with a political process, rather than talking about the human dignity of individual men and women. But I think it's been one of the themes this evening that while we can attribute dignity to human entities, we can attribute dignity to whole peoples. We can talk about the dignity of the Jewish people. We can talk about the dignity of the State of Israel. We can talk about the dignity of the Knesset, the dignity of legislation generally. We can talk about the dignity of the President of Israel and so on. Sometimes that notion of dignity is freestanding as applied to institutions and collectives, but sometimes it's connected with respect for human dignity in exactly the way that Justice Hendel said at the very beginning of his concepts, of his comments. We sometimes value the dignity of legislations, of institutions, because those institutions value and respect the dignity of individuals. And that, I think, is the case here.
Thank you. We'll just make perhaps one last comment, and then we'll open it up to questions. I have a comment, which is also a question.
Maybe we can begin now with a comment.
Okay.
Because we have just like 10 or 15 minutes.
Okay, so fine.
So if we can, okay. So.
Can I?
Present yourself, okay?
Dr. Kran, I'm from the faculty here. I want to take us back to the first part of your presentation on minority rights.
Yes.
I guess that we will all agree on the basic principles that you both talked about, but I guess minority rights are much more challenging than it was presented here. And minority rights breaches are much more challenging, especially when they are put in context. And from where I see it, I think that minority rights, or looking at minority rights, can be categorized vis-a-vis, you kept talking about majority rights, vis-a-vis majority rights of the majority and majority rights inside of the minorities group. And then the value of the status of the minority rights changes, changes, I mean, it depends. the judicial review of the minority breaches changes. And I will just give two examples. In cases where minority rights challenges, not necessarily contradicts, or mainly challenges, in Israel, radio broadcasting in Kippur Day, a case that was brought to the Supreme Court when Kippur Day was at the same day of the Eid al-Fitr, a Muslim holiday, and there was, according to the law, there shouldn't be any radio broadcasting. Now, it's interesting to see how the breach of this minority rights vis-a-vis minorities and vis-a-vis majority rights. And the second, maybe more challenging in my view, are cases where minority rights contradicts or challenges minority rights inside of the minority. And then we have another two classifications. One, more challenges, yes I am, just one sentence and that's it. Simple contradictions, how I can, and how I see it, when we talk about like murder on family honor. It's not simple, it's very harsh and very saddening, but it's simple because it's really easy to legitimize a breaching minority rights, and we say this is the red line and we cannot give any rights to this minority who does this kind of stuff. And another classification is what I call minor contradictions, and these are much more challenging contradictions. And an example is the veil in Catholic schools, for example. And so just one sentence and I'm finished. I have to say that I'm really fascinated, Professor Waldron, on your talk about diversity and majority. And as I see it, diversity, when you talk about diversity, the majority and minority classifications just fades away, because if you look at groups as diverse groups, every group has a majority and a minority inside of it. So it's really interesting to see how you say that. I'm sorry for taking so long.
Maybe we pick up some
collect a few comments and
then you can
go back to you for final.
All right, there's an awful lot there to answer.
Maybe a short question. Maybe the answer is long, but the question is short. Both of you think that majority, you spoke about majority and dignity, and you think that there is dignity in the majority, or you think that the majority is just a tool for legitimacy? Because these are two different things, right? And in different contexts, if you can get legitimacy without majority, it should be okay. So if there is something really intrinsic in majority, which I doubt, intrinsic in terms of its dignity, just, please explain.
Okay.
Then one student.
So thanks to you both. I really enjoyed it, Jeremy. As you know, I'm a very big fan of your work, and your work has been very influential in my own work, both in legislation theory and in constitutional theory. So I'm very tempted to talk long, and I'll be very brief nevertheless. So one, I want to spoil the harmony a bit. And this is a comment about the first round. And I think there might be some difference in your conceptions of procedure. I think you both are procedural democracy. You believe in procedural democracy. You both take procedure very seriously. But I think in the cases of Justice Hendel, he talks about deliberative democracy, where I think that Jeremy Waldron is more, you're less of a deliberative democrat and more a thinner version of procedural democracy. And do you see a tension there? And maybe I'll give a practical example. Let's say that the law had equal participation, minorities could have participated. There was majority vote, and you got the law, but there was no debate at all. As I understand some of Justice Hendel's decision, the debate itself is important, and the lack of deliberation in itself would make the law illegitimate. As I understand Professor Waldron's theory, for Waldron, if the procedures were fine and there was majority vote and everybody could have participated, that's enough. right? No. Okay. and another very short question, and more heretical maybe. Why do you need dignity here? Because I think that Professor Waldron's theory rests on the right of equal participation. So why, when you talk about the dignity of legislation, of course I understand why you need to say the title, as you said, the background, etc. But for your theory and why process is important, you need dignity, or is it enough to have the right of equal participation?
If we're going to collect 4, 5 questions, what are you going to do?
I think 12.
Would you like to go around?
Well, we have an immense number of issues raised
Yes.
here.
Yes.
Okay, so maybe
Maybe just one more.
Just one, and
Just
then,
holding the mic. I don't want to affront your dignity. But
So some people would have a fourth principle in addition to majority rule, minority rights protection, minority participation, and there would be the chance of the minority to become the majority at some point.
Yeah.
And you didn't have that, and I suppose Jeremy gives a partial answer later when he says majorities are not to be reified, but they are really the result of discussions rather than the input. What would you do in societies in which that is empirically problematic? Because people identify strongly not just as individuals, but as members of groups. And the groups have relations of majority and minority among them for ethnic reasons, for class reasons, for all kinds of reasons. Is it enough there to say to what becomes a reified minority to say you always participate in the discussions, but you never actually be effectively in the majority? Or would you have to find a fourth principle for that kind of society?
please.
So just on that last point, just partly because I don't believe strongly in the reification of majority at all. I certainly don't believe in majority rights, whatever that means. And I've tried to say definitely, look, the majority is just the artifact of the use of a certain decision procedure on a certain occasion. So there's always the possibility that somebody who's on the losing side of a given decision procedure may be on the winning side on a different occasion. You talk about the chance of a minority to become the majority later, and we need to understand what's meant by chance there. Does it mean politically realistic prospect? Does it mean that somebody must not be blocking it? What might be involved here? I live now as a disenfranchised permanent resident in the United States, but I used to vote in elections in Britain and in New Zealand. I never voted for a winning party, I don't think, ever. There are probably about 50,000 Bolsheviks in the United States who have no chance to become the majority. I don't think that necessarily indicates that they're being disrespected. So if the chance means, on the other hand, that they are systematically disenfranchised and not permitted to put their views forward into public debate, then it would be another matter. So we do worry sometimes in American law about discrete and insular minorities that are the subject of prejudice. And the trouble with that is that it interferes with the normal processes of accommodation, cooperative participation, the third dimension of respect for minorities that I talked about. When you have a minority that is discrete, insulated from the rest of society, and the target of prejudice, it often makes it very difficult for its members to participate actively in effective politics at all, and that's certainly a concern. There's a whole array of issues here. The only reason why I would hesitate to describe myself as a deliberative Democrat is that deliberative theorists, particularly again in the United States, which is the country I know best, in the political theory community, have often assumed that if you had a real deliberative democracy, you wouldn't need any of the sordid business of voting. Yeah? Because reasonable people like Rawls and Dworkin would sit around a table and they would deliberate, and it would go on forever. You know, Ronnie Dworkin would never allow himself the last word in an argument. The argument would go on forever, and eventually they would come up with conclusions, and the deliberative democratic theorists say that the need for voting shows that there's been something pathologically wrong with the deliberation. And I don't accept that at all. As Justice Hendel pointed out, it's one of the premises of this book, that reasonable people can disagree, and disagree all the way down on important issues. But I do believe very strongly in deliberation. It's just that it has to be, you have to have a theory of deliberation that dovetails with the need for voting, rather than a theory of deliberation that is embarrassed by the need for voting. And I think our experience of multi-member courts shows that. You have justices who are committed to deliberation in a highly formalized way, who nevertheless find it necessary to settle their disagreements by voting. So provided we emphasize that, then I'm perfectly happy with deliberative democracy. Yeah, on the point about dignity in the majority, I think I've already answered that. I think majority decision is a technique. It's a technique. It's a massively respectful technique, because it accords respect to every vote and gives each vote as much influence in the direction it points to as is consistent with equality. It's, I mean, these are just the rational choice theory axioms, but it's a technique. It doesn't endow any particular status.
Would you argue that if there is, let's say, a society which leads towards one person who is the wisest and he decides and they accept everything, they have less dignity?
I would say that, because I do think that in such a community where by some miracle we've managed to agree on who's the wise man, who should rule the society, we have implicitly denigrated, at least by comparison, the political acumen, the political beliefs, the deliberative capacities of the other 4.5 million people. So I do believe that political involvement is a matter of dignity. I mean, I know that we could just talk, if you like, about the right to participate, and just leave it at that. But the right to participate, like many rights, needs to give an account of itself. And we need to say, when somebody says, why should we count the views of, I don't know, this person on the religious right, or why should we count the views of this deplorable Trump voter? Because it's a human being, and human beings are of immeasurable importance, and part of that importance is rooted in their inherent moral capacities, which everybody has. We give a dignitarian account of why we value the participation of every last person. So just for that reason, even though, of course, the intermediate proposition is people have a right to participate, when that right has to give an account of itself, I believe it will reach down to a dignitary account. When people marched and protested for civil rights in the American South, sometimes they would march with posters saying, I am a man, yeah, I'm not a boy. And it's plain that that was a massively dignitarian statement, very brief, but massively dignitarian statement. Now, I couldn't agree more that minority rights is a vexed and difficult problem. You mentioned the role of minorities within minorities, and one of my favorite people who passed away, Susan Oken, wrote at length about that. The possibility that by crediting minority rights, we might be undermining the position of dissenters and minorities within those factions. It's always a possibility, particularly if dignity is being attributed to the minority group rather than to the minority members. Minority groups may be important for thinking about representation of the sort that I was thinking about. I'll give you an example. And I'm sure this has echoes in Israel, and I apologize for not knowing what they are. In New Zealand, which is where I come from, a country with which you should have no interest or concern, but there it is, the indigenous people who had the good fortune to arrive in the country 1,000 years before the Europeans, the indigenous people, the Maori people, have special representation in the parliament. The representation enables voters of Maori descent to choose whether they want to vote as Maori voters or as general voters. So every 8 or 9 years this option is made available, and they take the number of people who decide to vote as Maori voters, they divide that number by the average size of a district, because we have a partially district-based, not just a list-based proportional representation. And that may yield that there are 6 or 8 or 5 Maori seats. And so, as well as the proportional representation of parties and the representation of geographical districts, there is the representation of this privileged minority group on account of it being the original inhabitants of the land. And that's an interesting possibility. People say in Auckland, which is one of the most multi-ethnic cities on the face of the earth, why don't Polynesian immigrants or Chinese immigrants have the benefit of these similar arrangements? And everybody answers that very thoughtfully by saying, shut up. But it indicates a formalized version of a possibility that we ought to take very seriously, at least at an informal level, which goes back to what I said. It's hugely important to make sure that we take advantage of the size of legislatures to make sure that there is diversity. Your point, which I think is exactly right, that doing that is enormously difficult because each minority is diverse within itself, and it's never entirely clear who speaks for the whole group, and that is difficult, although it's no more difficult than any other constituency. But I agree with you that this doesn't solve any of the problems. I come back to the point that I did not want to speak about the rights of the majority. I wanted to speak, or even the dignity of the majority. I talk about the dignity of the majority process, because it's a respectful process. And I talk about the dignity of legislation, which is a majoritarian institution. But I believe we can do all the work we need to do in these matters by talking about the dignity of human individuals and how their votes are counted, rather than the dignity of groups.
The questions are very thought-provoking, and I'll think about them after this is over. So I thank all the questions. I'll briefly try to answer all the questions. In terms of the minority question, I welcome the comment. I think that you have to judge the issue concretely in specific context, and if you don't do that, then you're not really respecting the minority. I'll just say this based on an example you gave and a counterexample, just to show how complex it is. There was a decision that the Supreme Court had to decide, which was when there was the possibility of changing the threshold required for being able to be elected from the Knesset to, what was it, 2.5 to 2 to 3.5 or something, which is not a big difference. And there were cases in the European High Court that said that even 10%, requiring a requirement of 10% of the votes in order to be able to be in Parliament is legitimate. What the decision that was made, the following decision was made, I think it was unanimous, that we didn't...
One dissenting.
You dissent?
No. This time one wasn't.
Sometimes
it comes into line.
Sometimes he's all right, good. But there's no one who I enjoy disagreeing with more than Justice Meltzer. But getting back. Yes, okay. But what the decision was, which is very interesting, that there was the possibility that in the Israeli context, where there is an Arab population, which has to be recognized, that it could be, and it had 4 parties, which each one had about 2 or 3, that making this requirement could have an adverse effect on this particular population's right to be representative, not as one umbrella group, but as the minority within the minorities or different aspects of the minority. And so what we said was, at this point, we didn't want to interfere 2 months before the election, but based on the results, we would consider hearing the petition again after the election. The intent probably was to lower the amount of Arab representation, and in fact, the opposite was true. But what I'm trying to say is that there was a recognition that there should be sensitivity to the status of Arab Israelis. That's on one hand. On the other hand, there is, as you mentioned, a murder in the name of family honor. These cases happen that it could be that a young girl is found that she committed, she's no longer a virgin and so forth, and so the family, there are cases like this. I'm not saying it happens often, but the family executes her, saying it honors the family. And when I first had these cases, I thought about, at a certain point, talking about, and I wrote this in the decision, about having a a defense from culture, that maybe we should look at it differently. Because in that culture, that's the way it's looked. When I thought about it more, I thought that one of the important things of a state, of a government, of law, is that sometimes you have to push towards unity, and you have to ignore culture. You have to ignore minority sentiment to protect groups. And I think this tension between the first example and the second example is quite important. Regarding majority, this might sound strange. Your question sort of had the answer in it that it's impossible, so to speak, to see anything inherently positive about the majority. If I understood your question, if there was the wise man you could ask, we wouldn't need all this majority stuff. I don't share that view. I understand the view, I don't share the view. The reason I don't share the view is, I'll just point to the election. The past election, I think that there's something quite powerful about the fact that people go to vote, and take the last election, no one knew who would win, the result was a surprise. Where is their dignity in that? From my point of view, the dignity is in the following example. Einstein, if he voted in an election, his vote would count as much as someone who was mildly retarded. There's an equality there, which is almost irrational. It's almost irrational. But if you say that everybody's vote counts the same, to my point of view, that's raising human dignity. Now, I'm aware they could have decided something else. I'm not saying that the result is holy. The result could even be wrong if we could measure it by history. But to my point of view, there's a certain anchoring of true equality, which, to my view of things, adds to human dignity. And so if that wasn't the process, and we could somehow, there's a Talmudic story that there's a voice from heaven that tells the rabbis how to decide a certain decision, and the rabbis ignore it because they say it's not in heaven, it's for us to decide. Once you gave it the law, we have to decide. And how do we decide? They decide with the majority, and so forth. So I do have a certain view that the majority process is something, to my mind, very majestic, very ennobling. Yeah. In terms of procedural deliberation and debate, I think that it's important that there be the debate. You're quite right that, from my point of view, it should happen. To give you one example, there have been decisions where, in criminal cases, where the judge did not explain why he found the defendant guilty of a certain crime, and in those decisions, the absence of reasoning was enough, perhaps, to invalidate the result. And I think that deliberation is important. I believe in the process, particularly when there's no way to know. The more it's a question, there's doubt. The more there's a lack of clarity. I think that people getting together and talking and discussing, to my mind, is something positive. As to your questions to the ability of a minority group to be elected, it's a very difficult question, as you said. Would you say that in America, a woman has no chance of being president because it's never happened? I assume it will happen soon. But it's a difficult question. It's a difficult question.
Assume?
What?
Did you assume? Did you assume? Or
no, I assume it will happen soon. No, I said exactly what I meant to say. But to answer your question, you could argue the Israeli system, the government can fall 3 months after it's elected. In America, other than an impeachment charge, the government lasts for 4 years. Is that unfair? Is that something which is not right? Because for 4 years, the minority person has to wait? I don't think so. I see it as a little bit more complicated. But your question is right. What if there was a situation where one party kept winning over and over again? I would answer that the solution to that is not by law, but by other forms of, other aspects of society. I think that education is important. I think freedom of speech is important. And I believe, precisely for the same reasons, I don't think there's a right answer. I think people change their minds and certain things work and don't work, and they're charismatic leaders and all sorts of other factors. But I think in a society where there's stress on freedom of speech and also education, what you're talking about is less likely to happen. The last thing I want to say is that I think some of these matters are a question of culture, and that shouldn't be lost in this. For example, in America, today, someone who was not born in America or was not born in a way that America would recognize as citizen, as a naturalized system, cannot be president. To me, that's ridiculous. I thought this as a child before I came here. Why not? In Israel, you couldn't possibly have that situation because of the fact that it took a long time before there was someone who was prime minister who actually was born in Israel because of the nature of the government. I mention that because certain things, if we're talking openly and honestly, that societies agree upon or don't agree upon, is a question of culture. Yet, if we take a simple example, which is not a simple example, women's right to vote. So at the beginning of the 20th century, women didn't vote. And I assume people would say, well, that's common sense. Of course women shouldn't vote.
Voted in New Zealand.
What?
They voted in New Zealand.
They voted in New Zealand. I see we have patriotism. That's good. Okay, so in certain countries, was it in Sweden or Switzerland, it wasn't until 1971 where they actually allowed women to vote. Today, it seems the possibility that a society would decide that women do not have the right to vote is not realistic. And what I'm trying to say is that while there are disputes, one of the interesting things is as time goes on, there is consensus about certain issues, worldwide consensus in democracies, that only 100 years ago was very, very disputed. And that, I think, shows something about the fact that there is a certain direction, which I see as very positive.
Let me just, one concluding remark. So when we teach constitutional law, we usually have two chapters, of course. Actually, some schools have two different courses, right? One is the institutional aspect and the other is the rights chapter. And I think what you exemplified in the discussion is that these are pretty much a single story, perhaps anchored in the notion of dignity. And we're grateful to both of you for showing us the multiple connections. Just a couple of thank yous. First of all, to note that this session and the series as a whole is dedicated to the loving memory of Menahem Kuperstock, and we're really privileged to have this esteemed panel as part of that series. I'd like to specifically thank also our student who's about to graduate soon, Ori Aronson, for supporting the work of this and our coordinator, Dr. Bar-Ilan, who's the living spirit behind much of what we do here at the center. Again, final thanks to our two conversants, Justice Neal and Professor Waldron. It was an amazing privilege to have you with us and to listen to you. Thank you so much.
It's a privilege to be here. Thank you.
I just would like to say one thing, if I may. Certain days it just pays to get up in the morning, and this is one of those days.
For all of us.
I wrote in the decision that we are all the same, we are all different and the same, and that's the essence of human dignity. And one of the things which I take away from this is it's fascinating how two people from different countries who never met could think alike on so many issues, and it projects the fact that at least at this point in society, maybe there's something which we can talk about and call it law as a universal aspect or as a universal dialogue, as part of a process which we're involved with, and it's very exciting and it's very promising. Thank you.
Thank you very much.